Hey there, estate planning attorney Paul Rabalais here, and in this video we'll talk about what happens when somebody makes a will, but when they die there's no executor available to administer the will through the succession. All right, happens every once in a while, not that uncommon. Somebody dies and there's no executor named anywhere, and that could be for a number of reasons. Maybe the will was written a long time ago and there was an executor named in the will, but that executor died, or that executor's doesn't want to do it. And maybe there was even an alternate or backup executor named. Maybe none of those named executors are available. Or maybe the person who made the will just, they didn't name an executor. We see that sometimes because in Louisiana, we have laws that permit people to handwrite their own will. And since they don't really know the law extremely well, sometimes they forget to name an executor in the will. So sometimes you see notarial wills, which are the ones that are typed up, notarized, witnessed by two people, have the appropriate attestation clause at the end, signed in the appropriate places on each page. Sometimes you see those wills prepared by sometimes lawyers who don't have a lot of experience. Sometimes they're prepared by notaries. Sometimes they're prepared by others. Sometimes it's, who knows what. But the executor position just isn't adequately covered in the will. Somebody dies, they have a will, but now there's no executor to handle the succession process of managing the assets, paying the debts, and making sure assets get distributed according to the terms of the will. So what do? Well, when that happens, when somebody dies and they had a will, and there is no executor available to serve, then somebody has to step up and petition the court to be appointed as what's called a dative testamentary executor. So it's done in the same procedure as when somebody dies without a will, and an administrator has to be appointed. Similar procedure when someone has a will, but there's no executor to serve, then someone has to step up. Oftentimes, in ideal circumstances, all of the people that are named in the will agree and kind of quote unquote sign off on this person who is asking a judge to be appointed as the dative testamentary executor. So if there's conflict and perhaps more than one person applies for this position to be the dative testamentary executor, I assume there'd be some hearing in front of a judge, and then a judge would have to select who should be appointed as the dative testamentary executor. So you don't hear that term much, something that you don't hear every day, dative testamentary executor. Without knowing the background, you'd have no idea what that means, but that's the case when somebody dies with a will and there's no executor named in the will that's able to serve as the executor. All right, there you go. Hope you like it. Like, subscribe, and feel free to comment. We'll see you next time.